views from the Department of Veterans Affairs and advocates on 14 bills pending before this committee. 3 of these bills are my bills, and it's to increase support for surviving family members of veterans, to expedite veterans' appeals, and to expand skill bridge program for more men and women transitioning out of the military. My Caregiving for Survivors Act would increase the amount of dependency and indemnity compensation for surviving family members of service members and veterans who died in the line of duty from a service-connected injury or illness. While we can never fully convey our appreciation for their sacrifice, this bill is a meaningful step. It reflects our commitment to service members, veterans, and their families. My Veterans Border Patrol Training Act is a powerful tool to help transitioning service members maximize their military training and skill sets while also strengthening our national security. It establishes a pipeline for separating service members to work as Border Patrol agents for the Department of Homeland Security after they leave the military. It truly is a win-win for our veterans, and it's a win-win for our country. My Expedited Veterans Appeals Act would permanently increase the number of judges on the U.S. Court of Appeals for veterans' claims. This increase will ensure that the court is better structured to handle its increasing caseload and anticipate a number of new claims that may result from the passage of the PACT Act. We also have the GUARD Act on the agenda today. This critical legislation would ensure veterans are not being taken advantage of by people or organizations that charge veterans for helping them to get VA benefits. Last week, we heard about bad actors preying on veterans for financial gain. The GUARD Act is a common-sense first step, giving the VA the tools it needs to stop illegal benefits fraud by reinstating criminal penalties for individuals who assist veterans with VA claims if they're not accredited by the VA. Other bills on today's agenda would add student veteran centers to campuses across the country, improve VA's GA comparison tool, and provide easier access for student veterans to attend foreign institutions of higher education. I want to thank you all for being here today, for talking about these important bills on the agenda, and I look forward to today's discussion. While I'm still waiting for the ranking member to come, and he's on his way, I would just like to say there was an interesting situation that happened on the floor. We have a bill with five bills in it, a number of bills: support home health care, support mental health care, and that home health care have money available for VSOs to help educate their membership about what's going on in the VA. And another one for research on marijuana. It is my understanding that in the Republican caucus, they put up a fuss about that research. I just want you to know I put that bill forward so that veterans are going to know what they're putting in their body and the effects of that. We know the effects of opioid when it comes to painkillers. It's not good. And if there's other options out there for our veterans and the scientific community can back that up, why aren't we at least giving the veteran the opportunity to use that and know what they're putting in their body? If this bill fails in cloture, which it may, this is an incredible disservice that have been done to the veterans of this country. Not only for that bill, but for the other 4 bills that are a part of it too. But so be the United States Senate at this moment in time. It's a little bit disturbing. These bills passed out of committee unanimously, I think in the month of February, out of this committee. They're all bipartisan. They're all bills that, by the way, the veterans community asked for. And for the folks who represent VSOs in this room, you understand that every time that the VSOs come to talk to the joint session of House and Senate Veterans Affairs committees, one of the things that I always say is that this committee and I take our cues from the veterans, from the VSOs. So such is the way it is. And do you guys get robocalls too? So that's the way it is. Anyway, with that, I think, is he close? We can proceed. We have a panel of VA witnesses here today. Joseph Garcia, Executive Director of VBA's Education Service, will serve as the department's lead witness. He's accompanied by David Behrens, by Kevin Friel, by Nick Pamperton. David is the Chief Counsel for Benefits for Law Group in the Office of General Counsel. Kevin is Deputy Director of Pension and Fiduciary Service. And Nick Pamperton is the Executive Director of Veterans Readiness and Employment Service. So with that, we'll turn it over to you, Mr. Garcia, for your opening statement, and know that your entire statement will be a part of the record.
Good afternoon, Chairman Tester, Thank you for the opportunity to discuss pending legislation that would affect VA programs and services. With me today are David Behrens, Chief Counsel, Office of General Counsel, Nick Pamperin, Executive Director of Veteran Readiness and Employment Service, and Kevin Frio, he's the Deputy Director of Pension and Fiduciary Service. Mr. Chairman, with 14 bills on the agenda, I will highlight several in my oral statement. We have provided detailed comments in the full testimony to include areas of support and concern. The Fry Scholarship Enhancement Act would expand eligibility for the Marine Gunnery Sergeant John David Fry Scholarship to a child or spouse of an individual who dies from a service-connected disability during the 120-day period beginning on the first day of release from military duty. VA supports, subject to appropriation, but recommends revising the bill language to apply either to deaths that occur on or after the date of enactment or to deaths that occur on or after September 11, 2001. VA would also support, if amended, the Better Examiner Standards and Transparency for Veterans Act. This legislation would ensure that only licensed healthcare professionals furnish contract medical examinations for VA disability benefits. VA would also support, if amended, the Caring for Survivors Act that would improve and expand eligibility for dependency and indemnity compensation to certain survivors. VA supports the Love Lives On Act, but cites certain concerns. VA recommends deleting the proposed language that states the resumption of dependency and indemnity compensation payments for the surviving spouse of a veteran would be restricted to remarriages that occurred prior to the surviving spouse reaching age 55. That requirement would create disparate treatment for certain surviving spouses. The Student Veterans Transparency and Protection Act would improve how VA discloses risk associated with using educational assistance at particular institutions. This bill would also expand restoration of entitlements to include protection when an individual is unable to complete a course or program due to a federal or state civil enforcement action against the educational institution. Subject to the availability of appropriations, VA supports a section that would codify the GI Bill comparison tool. VA has no objection to Section 2D1A, as contracted benefit advisors are trained to provide a demonstration of the GI Bill comparison tool during the VA Benefits and Services course. VA does cite concern with the section that would require contractors and employees to provide educational counseling services. VA benefit advisors do not provide educational counseling beyond the curriculum that directs transitioning service members, veterans, and family to VA resources. VA does not support the proposed bill to establish a new Veterans Economic Opportunity and Transition Administration. VA appreciates the committee's focus on improving services and resources. However, we do not support the bill, as adding a fourth administration and executive leadership would limit efficiencies by creating redundant structures. Further, the existing one-on-one relationship with the Veterans Health Administration, which is critical to the PACT Act implementation, would become more complicated with an additional administration. Finally, VA supports the Veteran Improvement Commercial Driver License Act. This bill would modify the rules for approval of commercial driver education programs, thus providing more training opportunities for veterans and boost employment in this occupational area. VA also fully supports the Governing Unaccredited Representatives Defrauding VA Benefits Act. This bill would address the absence of criminal penalties in the current statutes governing the conduct of individuals who provide assistance with benefit claims. Mr. Chairman, this concludes my statement. We'd be happy to answer any questions you or other members of the committee may have.
Well, thank you, Mr. Garcia, for your statement. We have a great Democratic member of this committee in Sherrod Brown, who also serves as chairman of the banking committee, that I know that if I call him to ask his questions first, he'll do the same for our banking committee. So, Senator Brown, you're up.
But you've never called to ask that. So. Thank you, Chair Tester, and I appreciate the work that we have a package of issues on the Senate floor, and I appreciate the work John's doing on that. So I know he's just there for that. Thanks for holding this hearing first. Before turning to the witnesses, I just want to make a statement about something the VA, I think, has made a right decision, to thank you for taking the right steps and stopping the electronic health record rollout at additional sites until patient safety concerns are addressed. I spent a good bit of time either in Columbus there or talking to people there, and Secretary McDonough was helpful. And I thank the staff at Chalmers Wiley VA Center in Columbus for their hard work as they continue to meet veterans' needs while including those concerns. So Thank you for stepping up the way you did there. Thank you. I have a question for Mr. Behrens, if I could, regarding veteran complaints about unaccredited representatives. I can't stay for the second panel, so I wanted to highlight a few lines from Mr. Learman's testimony that I found troubling. Direct quote, at the March 29, 2023 hearing of the House VA Subcommittee, Krista Schreiber testified that veterans who've been charged an unreasonable fee can motion to the OGC to have those fees changed. She reported in 2022, VA returned $2.5 million in unreasonable fees back to veterans. She stated 40% of all claims they received were specifically about unaccredited representatives. Can you explain what an unreasonable, Mr. Behrens, and again, I apologize for not asking the second panel, can you explain to me what an unreasonable fee is and why a veteran could motion to have the fee changed?
Yes, I'd be happy to address that. We have presumptions in our statute regarding what is a presumed reasonable fee and a presumed unreasonable fee. So a fee of 20% is presumed reasonable, and a fee above 33% is presumed unreasonable. But we make reasonableness determinations on a case-by-case basis. There's specific authority in Section 5904 of Title 38 for VA to do that. And one of the reasons is because what's reasonable is dependent upon the facts of each individual case. If an attorney is able to convince a veteran to sign a fee agreement and then VA turns around and grants the claim the next day without the attorney having done any significant work on the case, the attorney might be entitled to a fee of 20 or 30% of the benefits under that agreement, but he would have done no work, he or she would have done no work, and in that case, the veteran would be entirely justified in seeking review or VA conducting its own review to determine whether the fee should be reduced.
Okay, thank you. I just wanted to restate my support for the GUARD Act. We should reinstate the guardrails to protect veterans from unaccredited organizations. If these organizations want to help veterans, they need to get accredited, period, as I believe you think. So thank you. Mr. Friel, I was glad to see that VA supports the Love Lives On Act with some amendments. Like my colleagues, I've heard directly from constituents whose lives have been put on hold because of the remarriage restrictions. It really is unconscionable. I look forward to working with my colleagues on this bill as it moves forward. So thank you, Mr. Chairman. Thanks.
Thank you, Senator Brown. I've got a few questions myself. The Caring for Survivors Act increases the dependency and indemnity compensation, expands access to benefit by reducing the number of years a veteran must be rated totally disabled for their spouse to qualify. DIC has not kept up with the cost of living, and this bill aims to bring it in line with other federal survivor programs, giving veterans, surviving families, a much-needed increase to their benefits. The PACT Act has also expanded access to survivor benefit programs, making more surviving families eligible to apply for benefits. So, the question is, how many additional survivors does VA anticipate will qualify for benefits under Caring for Survivors? Whoever would like to go.
Thank you for the question. Based off of what we did with our analysis on the costing, we anticipate in the initial year will be about 4,000 beneficiaries that will be brought into the program, and then subsequent out years will be a projection of 2,000 per year.
And that will go on, the 2,000 per year will go on?
Indefinitely.
Indefinitely, okay. How many survivors have already qualified for benefits under the PACT Act, and how many does VA anticipate are eligible to apply under the PACT Act?
So as of yesterday, we had approximately 4,600 claims that have been received from survivors related to the PACT Act. We've granted about 2,600 of those. We're granting at about just over like a 62% rate. So our anticipation when we did the initial analysis was we anticipated seeing 70,000 new beneficiaries being added to the rolls based off of the PACT Act as it relates to survivors.
Interestingly enough, I was at an MOA meeting last night and visited with those folks for a bit, and I had several folks come up to me, and one of them said that after the passage of the PACT Act, he had gotten 3 or 4 emails saying, here's what you got, here's the benefits now, and here's, if you guys had anything to do with that, thank you. Because it's good to see aggressive outreach, and I would include it in that. On the GUARD Act, VA accredited organizations, individuals are held to specific standards when they assess veterans with their claims. These accredited individuals are prevented from charging any fees for preparation, presentation, or prosecution of initial claims. However, there's a growing market preying on veterans, claiming to be consultants or coaches, and they're charging veterans fees for the same services veterans can get free from accredited individuals. Sometimes these fees are upwards of $12,000, which means either a veteran gives up months of their disability or they end up being hounded by third-party debt collectors. The GUARD Act reinstates criminal penalties for anyone who's charging veterans to assist with preparation of their claims without being accredited. Can you explain VA's position that we should maintain the current law of not allowing fees to be charged by those assisting with the initial fee appeal?
Yes, so the current law is that no one may charge a fee for assistance with an initial appeal. We'd be happy to provide views on any legislative proposals along those lines. But that limitation was put in place and has been in place for decades for a logical and noble reason, which is that veterans' benefits should be going into veterans' pockets to the largest extent possible. The system is designed, the VA adjudication system is designed to be weighted very heavily in favor of veterans and in favor of granting claims wherever possible. And in that environment, the thought is if a veteran's claim is granted by VA on the first pass, the veteran should be entitled to enjoy the full measure of those earned benefits without having to divert any of them unnecessarily to an attorney. And of course, that's balanced by allowing attorneys in after the first denial.
Thank you for the explanation. Can you tell me what will happen if we fail to reimpose criminal penalties for violating VA's accreditation?
Yeah, we would expect the market of actors who are charging illegal fees to grow. We're aware that there are many actors out there right now charging unlawful fees. We believe this is proven to be a potentially lucrative area of law, particularly because the system is weighted in favor of maximizing grants. A number of, just percentage-wise, a large number of these claims are going to be granted by VA with or without the assistance of the counsel, but it may therefore be relatively easy to make money by signing up claimants and letting the system operate the way it normally would.
So the period of transition from military to civilian workforce is a critical window for veterans. We've had many a hearing on this. One tool Congress can use to help can help with this transition is to establish employment pipelines from military to specific areas of civilian or government workforce. That's the idea behind the Border Patrol Training Act. It establishes a program for veterans to fill critical national security functions, leveraging what they learned in the military. So can you talk about how important it is to support transitioning service members from military to civilian life, particularly when it comes to training and employment programs?
Thank you, Senator, for the question. You know, within VA, obviously, veteran employment is a critical aspect of what we look to do. You know, while this piece of legislation we defer to DHS and DOD, we have shown through our 15 different skill bridge programs with DOD that there is true value. Take one, for example, which is the WARTAC program, where transitioning service members learn how to become claims adjudicators. Since 2014, we've had over 2,300 transitioning members go through that program. 1,900 graduate, over 1,700 got positions within VBA, and to this day, 76% of them still maintain employment. So there's real value in capturing these folks as they're transitioning out, and within the VBA WARTAC program, we've seen great benefits by soldiers transitioning right in to be able to help their fellow transitioning soldiers in the compensation rating process.
Thank you. Senator Tillis, if you're not ready, I'll go to Senator Blumenthal. Okay, Senator Blumenthal? As long as I get the next one. You get the next one. Unless Senator Hassan jumps in. No, I'm just kidding. Go ahead.
Thank you, Mr. Chairman. Thanks for holding this hearing. I think we all can agree that bad actors, con artists that exploit veterans are predators that ought to be addressed with strong action. That's why I've introduced the GUARD Act, the GUARD VA Benefits Act, along with Senators Bozeman, Graham, and thankfully Chairman Tester. Mr. Behrens, welcome back. I think we talked about the GUARD Act the last time you were here. And I want to ask you a question that we didn't address then, which is whether this problem of exploitation of veterans by individuals who may not be certified, the abuses of their rights and their pocketbooks is a growing problem that you think should be addressed.
Yes, thank you. We do think it's a growing problem. We've supported the GUARD Act and similar proposals because we've seen growing, action by bad actors in this area, meaning growing reports of individuals or organizations who are charging unlawful fees. It diverts veterans' benefits unnecessarily. It also, these individuals are acting without VA accreditation, meaning they have no oversight. So even to the extent they're providing services, we have no indication on whether they're quality services, and we have no basis for holding them accountable to the extent they provide a disservice to our veterans.
The changing demographics indicate to me that our veterans population is aging. Seniors are more vulnerable to these kinds of practices. Have you found that to be true?
Yes, we have seen anecdotally or through observation reports that a number of these scams target older populations. And so pension poaching is an obvious example, which involves, repositioning assets, and it often involves selling additional financial services to veterans or their survivors. Similarly, we've seen scams around home care services, sort of offering to assist with your claims if you sign up for a particular home care service. And so we have seen those populations being increasingly targeted.
I want to ask you about the GI Bill, and particularly the Basic Allowance for Housing, BAH. I think many of us have friends, relatives. I have 2 sons and a son-in-law taking advantage of the GI Bill. And in particular, I understand that the allowance, the BAH, expires or is prorated while students are not actively in the classroom. For example, a student veteran whose classes end on December 10th would receive the BAH for only 10 days. That veteran consequently would have to pay out of pocket for their monthly expenses for the remaining 21 days. Maybe, Mr. Garcia, shouldn't the current BAH rules be changed to better serve our veterans?
Sir, as a former veteran myself and who relied on the GI Bill to get me through college, and after 8 years enlisted service, I totally get what you're saying. I wouldn't be here without the GI Bill. I know we have looked, for example, at the half rate when a student veteran takes online courses. We would like to see if that could be changed. You still got to pay the rent whether you're online or not, right? So that's one example perhaps how we can look at. In terms of the rate itself, I believe there's a dependency on what the DOD rates are, right? We kind of match those, but we're happy to work with you in terms of what you're talking about, the proration part, and see what we could do there.
Well, prorating it or covering fully the time when a veteran needs to stay in the housing. The class may have ended, but he can't just go out and become homeless as a result. Right. He needs that support. And I get what you're saying about online, but why should it be only half?
So that was an original position, maybe related to COVID, I'm not sure. A lot of things maybe were perceived differently, what was online, what wasn't. But again, you still got to pay the rent whether you're in the classroom or not. So it's just something we can continue to work with you on and address that.
Well, thank you for that. If someone's taking classes online, the home becomes the classroom.
Exactly.
So it's all the more necessary.
Yes, sir.
Thank you. Thanks, Mr. Chairman.
Senator Tillis.
Thank you, Mr. Chairman. I also want to thank Secretary McDonough. We spent about 30 minutes together last week to give me an upgrade on the PACT Act implementation. As many of you know, I voted against the PACT Act. I support the legislation, need to, since there was a lot of stuff that we supported out of our office. And he's given me some hope that we can work out some of the kinks and fulfill the promise that we made. Mr. Behrens, I know in your testimony you were talking about the bill that I was talking about on timely reporting in response to congressional inquiries as placing an undue burden on you on particularly complex issues, and that we would hold the VA to a different standard of other agencies. I don't buy the last one because I want the VA to be one of the top-rated agencies for responsiveness, for supporting the veterans, for the best place to work. So if I may be treating you differently, some of that could be intentional because I want you to be better than the rest. And I also think you have less work to do than many other agencies. So can you tell me a little bit, I mean, let's just go through we can boil this down to simple use cases. I have some Coopers that I don't think were particularly complex that I haven't had a response to. I mentioned that in a prior hearing. If I requested something that you're going to say he's asking me to answer a question 6 months before I can do it well because I'm doing analysis or it requires data gathering, whatever process to formulate an answer, I don't think this bill would restrict us from sitting down and you offer a good case or someone within the agency and say, I can give you the Cliff Notes version now. If you want the expanded version, it may take me 3 months. In fact, I would consider that a partial response versus a non-response, which is what some of us have experienced. And I think Senator Tester pointed out it's a bipartisan problem. And I know that it existed across several administrations. So we're trying to fix it. And I'd like our office to work with you and figure out what other accommodations we need. In the VA, timeliness is very important. Most of the things that we're asking about are things that we in our heart of hearts believe is going to help the VA be better positioned to serve veterans. So rather than spend time in the office, I'm going to take your support right now as a lean no, but I'd like to get you to a lean yes by realizing many of you guys have been around for a while. You've observed my behavior. I don't attack the VA. I try to ask questions that help the VA get the job done. And oftentimes the answers to the questions that I'm asking are with the expressed intent of what I can do to make your job easier and make the outcomes for veterans better. So I can get the commitment from whoever's the appropriate person to meet with my office and let's walk through and see what concerns we can get addressed so we can hold the VA to a higher standard.
Mr. Behrens, you want to take that one?
Sure, thank you. I certainly appreciate the points and the elaboration of what is motivating them. VA certainly takes very seriously this relationship and our duty to provide you the information you need to help us. And we do work diligently to provide as timely and thorough and accurate answers as we can. And as we've stated, the complexity or other factors, collaboration with other departments may delay things. But to your point, we would certainly commit to exploring ways to improve the process, to include modifying it as you suggest, to have more touch points if a complete answer is going to take longer.
Good, and I think we can address that because I intend to continue to press on the bill. I told Secretary McDonough when I met with them, I was 30 or 60 seconds from being here for the committee hearing. I was just got off the train here, missed the hearing. I don't like bad actors, period. I hate bad actors in the VA space, and I told Secretary McDonough one of the questions I wanted to ask, do we believe everybody who are providing veteran service in a for-profit model are bad? All of them?
No.
Do we think more than half of them are? Do we have the data to substantiate the answer to that question I've just asked?
I don't think we have the data, and I don't think we know the full gamut of unaccredited representatives who are out there.
I, for one, think that we have many organizations that are doing a good job. And I think that our policies need to be instructed by real data and that our oversight should be instructed by outcomes. And what we do need to do is come up with some way of objectively measuring an organization, who engaged their services, what they got for it, how much it cost them. Bad actors just get put out of business, and good actors get more business. But I think one of the problems, the concerns that I have with on Capitol Hill, many people think all of them are bad actors, just like for-profit institutions of higher learning that have a pretty high placement rate and a fairly low tuition rate. Let's work on something that will give us the data that will allow you, maybe over time, to let that data be instructed by policies that can make it better. And Mr. Chair, the only other thing I wanted to mention, I was able to observe on C-SPAN later, because I was walking up here, the exchange between Senator Hirono and Senator Sullivan on a bill that he's proposing for the Camp Lejeune toxics. I think it's fair to say our office had a little bit to do with the drafting of that bill.
You did.
Yeah. And I hate the ads. And I also am concerned with just how much money is going to go into the pockets of a law firm versus providing the veteran with support. I think the registration period for the Camp Lejeune Act gives us a remarkable opportunity to find more veterans who have no connection to the VA. Now, I know that there are going to be problems with getting a cap on legal fees through, but just if I could, and Senator Hassan, I apologize for this. I started thinking about a kind of patriot Bill of Rights. An attorney that has a retainer agreement that they're going to have a prospective veteran sign has an obligation to say, have you contacted the relevant agency? In this case, it would be the Department of the Navy. Have you ever contacted the VA for services? We have a lot of people we don't have a connection to, but they're seeing a hell of a lot of ads right now, and some of them may be calling that number. So the first question is, do you realize that you have a right to call this agency, and you may have the nature of the claim may be one that you don't need legal representation? And if you've called that agency and you didn't have a good response, do you know that your Congress member and your 2 senators also do casework like this? And we advise clients when we think the complexity of their case is too great for us to carry it forward. Have you done that? Are you also aware, prospective client, that there are several veteran service organizations that are also developing expertise here? Are you aware of them? Have you contacted them? And then, are you also aware that you may be charged exorbitant fees for this, and we'll let people justify what that fee needs to be before they sign a retainer agreement? What would be wrong with a concept like that that requires every attorney, maybe even any organization that's in the for-profit veteran servicing benefit, to make sure that these veterans know what rights they have that have nothing to do with using anything but an agency and a congressional office and a veteran servicing organization before they ever go to an outside source to pay for a service or pay for litigation? On its face, you're an attorney, so you're never going to say yes to a question like that, but on its face, do you see anything directionally wrong with that concept?
Nothing wrong with the concept. Obviously, if we're talking, we'd be happy to provide views on any proposed legislation, but certainly anything that helps educate veterans of their rights and the resources available to them.
Expect a draft. Maybe when we get together on the pending legislation, we can talk about that one too. Thank you, Mr. Chair. Senator Hassan, I'm sorry for going over.
Senator Hassan.
Well, thank you, Mr. Chair. I want to thank you and the ranking member for this hearing, and thank you to all the witnesses here today for your work. Mr. Garcia, the VA runs a wide variety of important benefits programs to support and empower veterans, and we've talked about some of those as I was coming in. I was hearing you talking with Senator Tester about some of them. We do that in recognition of the service and sacrifice that veterans have given to keep our country safe, secure, and free. For example, in addition to processing disability claims, the VA also runs programs like the GI Bill for education, the Home Loan Program for housing assistance, and career assistance programs like veteran readiness and employment. So just briefly, can you talk about how important these programs are to veterans and transitioning service members?
Ma'am, I may turn to my colleague, Nick Pampern, on the VRNE to start, and then I can pick it up after he's done.
Yeah,
Okay.
and just give me, 15, 20 seconds on each, because I got a couple of follow-ups.
Sure. Yes, ma'am.
Yep.
Absolutely, it's a great question. What I can tell you is our longitudinal study, it's a 30-year study for VRNE, shows that veterans who go through the VRNE program, on average, earn $20,000 to $30,000 more annually than veterans who discontinue the program. And stop right there. We're an employment program, and our program demonstrates, significant results for veterans.
Great, thank you. Anything you wanted to add, sir, or just about the other programs?
Well, all the programs are extremely important, right? Especially we found for the dependents, the educational assistance that we can provide dependents really are striking in how much difference they make. We've seen that in surveys. So that's something I think I'd like to call out.
Okay. Now, these types of, let me back up. In light of how important the programs are to veterans, I want to learn a little bit more about how they're administered. Can you tell me about the professional background and expertise of the VA employees who administer the VA's employment and education programs?
Sure. For VRNE, the primary case manager is a master's educated counselor in vocational rehabilitation services. We are the only affirmative education program, or only affirmative program within VBA that has a specific cohort of an educational requirement. So within VRNE, it is a master's educated counselor.
Okay. And other employment programs, similar kind of career counseling, training?
Within the VRNE program, we are the employment program.
Yeah.
They are the GS-12 master's educated counselors.
So these types of experts are critical to the effective administration of the VA's economic benefit programs. I want to turn to the type of expertise that's best suited, though, to administering the VA's disability benefits process, which involves lawyers and doctors and healthcare experts. So can you tell me about the professional background and expertise of the VA employees who administer the VA's disability programs?
Yes, ma'am. So it varies. We have attorneys that we hire. We've had nurse practitioners that we hire as far as rating decisions and working in that area. From a claims processor, we typically look for a college degree, at least a bachelor's degree. They come in as a GS-7 level, and then they, through the training that we provide them, because it is a unique skill set.
Right.
And then we work to get them up to speed and we have quality and oversight that ensures that the production that we get is the best that we can get.
But you're really looking at an analysis of healthcare claims and within an adjudicatory process, right? I mean, it's determining disability claims.
So yes. So I mean, in that arena, it's not. I am pension and fiduciary, so that is more of a compensation.
Yeah.
So I would be happy to take that back and work with compensation service to get your reply about what they look for.
Well, what I'm really trying to get at here, and just really want to note, is that there's a difference in the expertise that we need and I want to just highlight the reasons behind the bipartisan bill I have that you all know about with Senator Rubio, which would create a separate administration within the VA that would dedicate full attention to the VA's economic and transition assistance programs, while the existing benefits administration could focus more completely on processing disability claims for veterans. My concern is when you have one administration that's really focused on adjudicating disability claims, you don't necessarily focus in the same ways that you could on economic empowerment and transition. And so I hope to continue discussions with all of you about that bill and how we make sure that we are running these programs as effectively as we can for veterans. Thank you. Thank you, Mr. Chair.
Yeah, thank you, Senator Hassan. I want to thank you guys for being here today and being forthright and willing to work with us. So you are dismissed. Thank you. We've got a second panel coming up. I've got a bunch of folks that are very familiar with this committee. We've got Shane Learman, who's Deputy National Legislative Director of Disabled American Veterans. We got Tammy Bartlett, Vice President of Government Affairs for Student Veterans of America. We've got Ashlyn Haycock-Lohman, who is the Deputy Director for Government and Legislative Affairs at the Tragedy Assistance Program for Survivors. And we've got Diane Boyd-Robert, who is Executive Director for the National Organization of Veterans Advocates. I want to start by thanking all of you for being here today. We appreciate getting the perspective from the veterans who are on the ground. More importantly, we appreciate what each and every one of you do for the veterans throughout this country. We will start with you, Mr. Learman, for your opening statement, and then we'll rock and roll right down the line. Go ahead.
Thank you. Chairman Tester and members of the committee, DAV is grateful for the opportunity to appear before you today, and our written testimony covers all of the 14 bills being considered. However, my comments will focus on just a few of these. DAV was founded over 100 years ago by World War I veterans who banded together to assist each other in establishing their claims for earned benefits. Today, DAV is a congressionally chartered and VA-accredited veteran service organization that provides free VA claims and appeals representation to veterans and their families. I am a disabled veteran and a VA-accredited DAV benefits advocate, and I've been assisting veterans and their families with claims and appeals for 25 years. Based on this experience, we appreciate the importance of S-280, the Best for Vets Act, as it would ensure that only licensed healthcare professionals furnish disability examinations under the VA Contract Examiner Program. The VA examination is a vital part of the claims process, as it can be determinative of the existence of a current condition, or if the veteran's illness or injury is related to their active military service, or specifically the severity of that condition. Thus, having medically licensed professionals will only benefit the process. DAV supports the Best for Vets Act. Part of our mission includes protecting veterans and their families in the claims and appeals process, which is why DAV strongly supports S-740, the Guard VA Benefits Act. It would reinstate criminal penalties for those entities who charge veterans and their families fees for preparing a claim, all the while intentionally skirting around VA accreditation requirements. To be clear, these companies were created knowing they were operating in violation of VA law. Additionally, many have refused to stop their practices even after receiving cease and desist letters from VA's Office of General Counsel. For many of our nation's disabled veterans, VA disability compensation can be the difference between making ends meet and more severe outcomes, such as homelessness. DAV believes that no veteran should pay these entities to file a claim. Veterans have already paid with their service and sacrifices. Mr. Chairman, we thank you and Senator Bozeman for introducing S-414, the Caring for Survivors Act. This bipartisan legislation would ease the eligibility criteria for dependency indemnity compensation, DIC, and increase the monthly benefit amount to match benefits provided by other federal survivor programs. Specifically, the bill would increase the amount of DIC to 55% of the rate of the monthly compensation received by a totally disabled veteran. This will provide parity with the amount survivors of federal employees receive. And it will expand eligibility for DIC by replacing the 10-year rule with a graduated scale of benefits that begins at 5 years for initial eligibility at 50% and gradually reaches the full benefit at 10 years. For example, if a veteran is rated as totally disabled for 5 years and dies of a non-service-connected cause, a survivor would be entitled to 50% of the DIC benefit. DAV fully supports the Caring for Survivors Act, which is extremely important to our members. Just within the past 2 weeks, our members have sent over 28,000 emails to Congress in support of this legislation. That's right, I'll say it again. That's right, 28,000 emails in support. DIC rates have changed little since 1993. It is time we provide adequate compensation for the survivors of our nation's veterans. Finally, Mr. Chairman, we thank you and Ranking Member Moran for introducing S-897, the Expedited Veterans Appeals Act. We believe a permanent increase of judges from 7 to 9 will improve the timeliness in appeals at the Court of Appeals for veterans' claims. The court has sole jurisdiction over the decisions from the Board of Veterans' Appeals, which has predicted they will decide more cases this year than at any other point. DAV supports S-897, and we point to the court's own statement, 7 permanent active judges are not adequate. This concludes my testimony, and I look forward to any questions you and the committee may have.
We will have questions, Mr. Lerman. Thank you very much for your testimony. Next up, we've got Tammy Bartlett.
Chairman Tester and members of the committee, thank you for inviting Student Veterans of America to submit testimony on legislation pending before you today. And thank you for considering several pieces of legislation that would impact student veterans and military-connected students in higher education. SVA has a mission focused on empowering student veterans, and we are committed to providing an educational experience that goes beyond the classroom. SVA's views on 7 bills can be found in my written testimony, but I will take this opportunity to highlight 2. SVA supports S-498, the Veteran Education Empower Act, which would reauthorize a Department of Education grant program designed to coordinate resources and services for student veterans through veteran centers. Over 8 years ago, as a new student at Temple University, I met with the Associate Director of Adult and Veteran Student Recruitment. She mentioned the university had a student veteran chapter. I smiled and I began to feel at ease, knowing that the next step in my journey would be surrounded and supported by those who also served. As a first-generation college student leaving the security of my hometown community college, I knew I would need a place and people to connect to on campus. After not self-identifying as a veteran for over 10 years, this might be the place to embrace that label. I soon became active in the Temple Veterans Association, and I participated in the grant writing task force to find funds to support our dream of a centralized rendezvous on campus. The grant was awarded, and in the fall of 2016, Rear Admiral Lynch, the then president and now chancellor of Temple University, Richard Englert, and the late General Colin Powell officially cut the ribbon to open the Temple's Veteran and Service Military Center. The benefits of veteran service centers is more than anecdotal. A study published in the Journal of Education found that post-9/11 veterans were 94% more likely to graduate if they use a veterans center. A veterans center is an oasis for student veterans, military-connected students, family members, and survivors. It is where we escape the noisy and often bustling computer lab, host resume writings and mock interview sessions, and find a place of refuge from the academic and personal stressors of the post-traditional student life. SVA and other veteran-serving organizations can connect with those on campus at a simple, single location. Programming at veteran centers can provide education and training for campus facility and staff to further aid in creating a more welcome community for transitioning student veterans. This legislation would support a single dedicated points of contact for veterans and veteran-specific orientation, which has been shown to increase student veteran success outcomes by 15% and 10% respectively. There are just a few of the more important support mechanisms of this bill that would make it possible to have on campuses across country through a well-equipped student veteran center. SVA supports 1090, a bill to direct the Secretary of Veteran Affairs to update the payment system of the department to allow for electronic fund transfer of additional education assistance to foreign institutions and higher education. SVA has heard from numerous veterans and their family members encountering major obstacles using the VA education benefits overseas. One of many issues they face is their institution being barred from approval from VA education benefits because it does not have an employer identification number or a U.S. bank account. VA recently indicated that an EIN is no longer required, but the institutions are still required to have a U.S. bank account due to the current IT limitations. We believe VA is already contemplating a fix for this issue, but the department's failure to act thus far continues to limit beneficiaries' choice overseas. The continued success of veterans in higher education in a post-9/11 era is no mistake or coincidence. In our nation's history, educated veterans have always been the best of our generation and the key to solving our more complex challenges. Today's student veterans carry this legacy forward. We thank you, Chairman and committee members, for your time, attention, and devotion to the cause of veterans in higher education. As always, we welcome your feedback and questions.
Thank you for your statement, Ms. Bartlett. Next, we have Ms. Haycock-Woman. You are recognized.
Chairman Tester, Ranking Member Moran, and distinguished members of the Senate Committee on Veterans Affairs. The Tragedy Assistance Program for Survivors is grateful for the opportunity to testify today on behalf of the over 120,000 surviving families TAPS is honored to serve. TAPS strongly supports S 1266, the Love Lives On Act, and we thank Ranking Member Moran and Senator Warnock for reintroducing it yesterday. A top legislative priority for TAPS is ensuring military surviving spouses are allowed to remarry at any age and retain their benefits. Current law penalizes surviving spouses if they remarry before the age of 55. Given that many post 9/11 surviving spouses are widowed in their 20s and 30s, we are asking them to wait over 20 years to remarry and retain their benefits. Military spouses are among the most unemployed and underemployed populations in the United States. Due to frequent moves, deployments, and expensive childcare, military spouses face many challenges to employment and are unable to fully invest in their own careers and retirements. For many families, military retirement is considered the household's retirement. These barriers continue when a military spouse becomes a surviving spouse. Many surviving spouses have to put their lives on hold to raise grieving children. They rely on survivor benefits to help offset the loss of pay for their late spouse and their own lost income as a result of the demands of military life. The stories of surviving spouses Rebecca Morrison Mullaney and Linda Ambard Rickard shine light on the issues and why the current law needs to change. Rebecca was widowed at 24 years old when her husband, Apache helicopter pilot and West Point graduate, Captain Ian Morrison, died by suicide in 2012. Rebecca had to leave her home and career after Ian's sudden death and attempt to rebuild her life. She could no longer pursue the career she had trained for and had to withdraw from her graduate program. In memory of Ian, Rebecca has dedicated her life to preventing suicide. Through her work, she met her now husband, Brennan, also an Army veteran and West Point graduate. Rebecca and Brennan married knowing that she would lose all of her benefits, but they made the difficult decision in order to build a family together. 9 months ago, they welcomed their first child, a boy, whom they named in honor of Ian. Just because Rebecca has remarried does not mean she loves Ian any less. She is a wife to both men. Ian is a daily part of both of their lives. Brennan even went to the cemetery to promise Ian he would always love and support Rebecca before he proposed to her. Rebecca is one of the less than 5% of surviving spouses who have chosen to remarry before age 55 and lose their benefits, even though Ian earned those benefits through his service and sacrifice. Linda's story is different. She was widowed at 50 after her husband of 23 years, Major Phil Ambard, was killed in Afghanistan. Just like Rebecca, Linda was fortunate to find love again after the loss of her husband. But because she was over 55, Linda did not lose her benefits upon remarriage. She was not forced to decide between her own financial security and being alone for the rest of her life. The only difference between Rebecca and Linda is their age. They both lost their spouses to military service, and they both found love again, but only one of them is penalized for it. All they are asking for is the right to choose how they move forward and pick up the broken pieces of their lives, lives that were permanently changed because they loved and married someone who died due to service to our country. In addition, TAP strongly supports S414, the Caring for Survivors Act, and thanks Chairman Tester and Senator Bozeman for reintroducing this important bill. Raising DIC from 43 to 55% of the rate paid to 100% disabled veteran will provide parity with other federal survivor benefits. More than 450,000 survivors receive DIC from the VA, but the current rate for surviving spouses is $15.62 per month and has only been increased by COLA since 1993. TAPS and the survivor community have supported strengthening DIC for many years. As surviving spouse Katie Hubbard states, increasing DIC would allow me to be able to afford groceries and childcare, medical expenses, and home and car maintenance while just trying to survive. It is time we fix this inequity. Our nation's surviving families should not be receiving less than their civilian counterparts. TAPS also strongly supports S350, the Frye Scholarship Enhancement Act, which expands Frye Scholarship eligibility to the families of those who die in the 120-day release from active duty period. If a veteran dies during the 120-day refrab period, they are considered an active duty death for all benefits except the Frye Scholarship. The only difference is that these families are eligible for Chapter 35 instead of Frye. This bill would bring long overdue parity to these surviving families. Finally, TAPS would like to express support for S740, the Guard VA Benefits Act, S1090, the GI Bill Foreign Institution Electronic Payment Act, and the Student Veterans Transparency and Protection Act, all of which would positively impact the surviving families TAPS supports. Thank you for the opportunity to testify today, and I look forward to answering any questions you may have.
Thank you, Ashley. Now we have Ms. Rauber.
Chairman Tester, Ranking Member Moran, and members of the committee, NOVA thanks you for the opportunity to testify. Our written statement addresses other bills on the agenda, but we will focus today on S740, the Guard VA Benefits Act, and explain why accreditation provides important safeguards to veterans and reinstatement of penalties is long overdue. We thank Senators Bozeman, Blumenthal, Tester, and Graham for reintroducing GUARD and their continuing leadership on this issue. The GUARD VA Benefits Act is necessary to protect veterans from unaccredited representation, illegal charging, predatory practices, and fraud that is being flaunted and excused in the name of choice. Accredited representation provides veterans with due process, choice, and the best outcomes. When a veteran retains an accredited attorney, agent, or VSO, that representative obtains access to the veteran's claims file and VA databases. The advocate can develop a comprehensive, coordinated plan for representation at all levels of the process. The advocate can request medical and service records. The advocate can call or email a VA employee on the veteran's behalf. The advocate can appear at a hearing with the veteran and submit argument. The advocate can work to ensure the appropriate effective date is assigned, benefits are maximized, and expedited treatment is requested when warranted. Furthermore, accredited agents file every single fee agreement with VA. When a veteran chooses to hire an accredited agent or attorney, they have peace of mind that VA will enforce reasonable fees and allow for due process. NOVA fully supports these protections. You are now hearing from unaccredited claims consultants that the accreditation process is broken. These arguments ring hollow when made by those who have never subjected themselves to vetting by VA, submitted a single fee contract for review, and publicly state they cannot make enough money abiding by the same laws and regulations that our members do. While predatory practices and contracts vary, we see some common elements and hear common complaints. Consultants aggressively advertise online and solicit veterans electronically to file claims, fraudulently maintaining they can get faster decisions or otherwise guaranteed results. Consultants gather information and prepare an initial claim or claim for increase and coach the veteran filing it. Sometimes the claim is submitted by a consultant using the veteran's e-benefits login information. Consultants charge illegal fees with contracts requiring 5 or 6 months of the veteran's future increase. Some commit fraud by reaching back in to take fees from awards unrelated to the original action. Unaccredited claims consultants also interfere with existing power of attorney relationships. For example, one of our members reported that a company prepared 4 claims for her client, promising faster results. The veteran submitted 4 VA disability benefits questionnaires completed by a nurse practitioner procured by this company. On the consultant's advice, the veteran asked VA not to schedule any examinations for him. The consultant had no idea that 2 of these claims were already pending at the Board of Veterans' Appeals, and VA denied them. VA denied the other 2 claims because of the veteran's stated unwillingness to submit to any additional examinations. Some companies also use predatory collection practices. Aware that a veteran might not receive enough retroactive payment to fulfill the amount for 5 or 6 months, they set up payment plans that charge interest. Other companies have employees who harass veterans for payment that is clearly not owed. For example, one company charged the client of a NOVA member $6,000 for an increase that was not based on the material prepared by the company. The company's in-house debt collector called the veteran 20 times about the alleged sum owed. They asked the veteran to send screenshots of his e-benefits and va.gov account and asked the veteran's accredited representative to send the rating decision to them for review. Other consultants target elderly veterans in nursing homes with promises of aid and attendance benefits. For example, NOVA recently received a call from an individual assisting a veteran in a nursing home. She reported a consultant had come to that facility and told the veteran they could help him apply for benefits, but they needed his bank account information first. VA has repeatedly told Congress that they need reinstatement of penalties to stop fraud and predatory practices because these companies ignore cease and desist letters. The accredited advocate community supports the GUARD VA Benefits Act. Every day that penalties are not reinstated is another day that a veteran or family member is exploited. We ask this committee to advance GUARD. Thank you again for the opportunity to testify and are happy to answer any questions.
Thank you for your testimony, Ms. Brauber. Senator Hassan?
Well, thanks, Mr. Chair, and I want to thank the panel for your testimony. And I just had really one question for you, Mr. Lehrman. In your written testimony, both DAV and actually to you, Ms. Bartlett as well, Student Veterans of America both expressed support for my bill with Senator Rubio to create a separate Veterans Economic Opportunity and Transition Administration within the VA. Can you expand on that testimony by telling us a little bit about the value that your organizations and your members see in creating this new entity to focus on the VA's economic benefits? And I'll start with you, Mr. Lerman, and then Ms. Bartlett.
Thank you very much for the question. There are several different things we could point to within the education or employment parts that didn't get the amount of attention that it needed. And real quick, VRNE for 8 years has been trying to establish an electronic case management system for their counselors. 8 years. We don't have one yet. They've already spent $20 million, and now they're about to embark on the third one. We believe that is a prime example of if there was somebody focused, dedicated, overseeing that, we wouldn't be where we are 8 years later, $20 million, and we still don't have the tool they need.
Okay, thank you. Ms. Bartlett?
Thank you, Senator, and I appreciate the question. By establishing that fourth administration, it gives the opportunity to have the economic opportunity looked at, stronger messaging and outreach, along with possibility of reviewing programs and adding that modernization piece into it.
Thank you very much. Thank you, Mr. Chair. That's all I had.
Senator King?
Thank you, Senator. I'd like to ask a question about the GUARD Act, and I completely agree that it's important and necessary. What is the accreditation process now? What does it take to become an accredited representative?
Well, Senator, that depends on whether you're a VSO, an attorney, or an agent. So VSOs are accredited under the umbrella of their congressionally chartered organization, but that is on an individual basis.
So, but if you're a member of the Legion, is that enough?
No, you still have to submit information to VA. I'm more familiar with attorneys and agents. Attorneys have to submit evidence of being in good standing with the state bar. They have to complete CLEs that VA requires. Claims agents are slightly different because they are lay people that are neither part of the VSO community or an attorney. They have to have a background check conducted by VA. They have to also participate in CLEs, and they are required to complete a claims agent exam, which is to know that these people have some common basic
Is this do you think the process itself is timely and effective?
I definitely think the process is effective. We always think that VA can do things a little bit faster. So we know that sometimes it takes a little longer for agents to be accredited. But we also think that that's really important because you want to be sure that these people can do the job. Yeah. And we think maybe they could offer some exams more frequently. That would be a big help.
Along the lines of representation, I see Senator Sullivan has joined us. One of the issues that we're going to be debating and trying to work through is the appropriate cap on contingent fee percentages, particularly with the Camp Lejeune. I would just like to survey the panel, and because you're involved in these kinds of matters, what's reasonable? Senator Sullivan has proposed, I think, 17%. There's discussion of 30%, which is more of the conventional attorney contingent fee. Help us out here. Any thoughts you have on this matter?
Senator, I'm going to disappoint both you and Mr. Sullivan by saying that our members are not mass tort attorneys. Our members are not the people who've been advertising. Our members are people who are experts on
Oh, I understand that.
Yeah.
I wasn't casting aspersions. I'm
Yep.
just asking you to help give us guidance on what the right number is. 17, 22, 31?
We don't have a number. We just, there needs
We've got to arrive at a number. That's what I'm looking for.
I understand that. There needs to be sure that there are people who are able to competently represent veterans and their families in these cases. And that's all I can really state today.
Okay. One other more general question for the panel. This is a good list of legislation that we've been talking about here. Are there other things that, if you had a blank sheet of paper, you would bring to us in terms of improvements in the VA process that we're not attending to adequately at this point? This is a big opportunity for you, Shane.
Thank you, Senator. It is. And
I'm opening the door, man.
I don't think there's enough time for this committee to listen to me for the next 5 hours explaining them.
Well, I've got a minute 39. So.
Real quick, one of the issues that we've been seeing as part of the claims process, And there's been a bill on it the last few Congresses, and that goes specific to MST claims and processes. There's been several hearings about it in the House over the several years on VA not getting the accuracy correct when it comes to claims based on military sexual trauma. We think that is something that really needs to be addressed. It's been something the VSO community has been talking about for many, many years. And if I were to give anything, it would be to find a better way for VA to get it right the first time.
Thank you. Any other thoughts?
Yeah, I'd like to jump in. I think a few years ago, we worked on the Appeals Modernization Act with some of the people in this room. And while we think that that bill has done some really good things at VA, we think maybe it's time to sit down and take a look at that. We think there's some things that could be improved, particularly taking a look at the Board of Veterans' Appeals and how long it's taking for decisions to be made there.
Great, thank you. And I take it you all support the GUARD Act. Is that accurate? Yeah. Thank you, Mr. Chairman.
Thank you, Mr. Chairman, and I'm just going to follow up where my good friend Senator King left off. This is the Camp Lejeune Act that we passed last year, and I think every American's seen all the advertisement. We had a hearing last fall that the VA representative mentioned. It's over $1 billion in ads. It's probably gotten way north of that. And so I know that maybe all of you aren't ready to talk about a specific cap, and I understand that. We're working through that, but would all of you agree that you need some cap on contingency fees, right? Pretty much every federal law that enables a claim against the government, and now we're talking way outside the realm of veterans, they all have caps on contingency fees, every law, with the exception of this one. I won't go into the details of why that didn't happen. The Biden administration, as we were negotiating the Camp Lejeune Act and the PACT Act, of which it was part, the Justice Department of the Biden administration encouraged this committee to adopt caps. So it didn't happen. That's it's just not good for the veterans and the Camp Lejeune Marines and families that are seeking compensation. So can I just real quickly, does everybody agree we need caps on contingency fees? So there have been reports of 40, 50, 60% contingency fees, which is just outrageous. So do you guys all agree that we need caps? I want to start with you, Shane.
Thank you, Senator. While we don't have a specific resolution for this bill,
no, I know.
DAV does believe, and we do have resolutions that does support capping attorney fees specifically within the VA system. So yes, we believe that that is something that must be done to help protect veterans.
Yeah, absolutely. Okay, Tam.
Although SVA doesn't directly impact or have an impact on this, but we do have student veterans who are going through their comp and pen benefits, and we rely on our VSO friends to help them through that process.
Okay, Ms. Haycock-Loman.
Yes, of course. Surviving families are at high risk for being taken advantage of by bad actors, and anything we can do to reduce that for surviving families is important to us.
Great. Ms. Robert?
We do not have a position on it, but I would point you to the fact that our members are capped under VA disability law,
Yeah.
and that we really think that GUARD is necessary because some of those same practices you are seeing in Camp Lejeune, we are seeing with the unaccredited claims consultants.
Okay, so let me, Mr. Chairman, I hope that we can, again, get to a spot. I've been kind of going up in the negotiations. The issues with regard to contingency fees, I understand we want good lawyers to be able to represent the Marines and Marine families. As you know, in the Camp Lejeune Act, though, there's a lot of elements of that the defense of the government have been waived. So this is not as complicated as a full trial that starts with discovery and has a full trial and litigation. This is a much cleaner process for the attorneys representing the families, which is another reason we believe 17% cap and 12% on filing is more than generous for our lawyers. I'll just make one final point. There's a 2-year timeline for families to file under this law. So, unlike the GUARD Act, which I know has been literally been considered since the mid-2000s, we're getting to the point where, you know, we're running out of time, and the more that this gets delayed without fixing the attorney fee cap issue, the more Marine Corps families and Marines who we're trying to help are gonna not get the justice that they deserve. So I really appreciate the panel here. I want to work with everybody on the committee. Again, this one, you know, you can rope-a-dope an issue long enough to where it goes away. That'll happen here, but it won't be the right outcome. We all know that that'll be enriching certain trial lawyers. I'm not saying they're all bad, but there's certainly some unethical ones at the expense of Marines and their families, and I think everybody knows that's just wrong. It's just wrong, and I certainly hope the Congress can fix it. Thank you, Mr. Chairman.
Thank you, Senator Sullivan. It is my understanding that Senator Durbin has a bill, you've got a bill. I think there's an opportunity here to find a spot that works.
I hope so. I hope we can do it quickly, though, because like I said,
Right, no, I hear you.
the timeline is.
I think it's hard to argue 40, 50, 60% contingency.
No, that's.
I think it is easy to argue comprehensive representation, too.
Yep.
So it's good. I appreciate that. I've got a couple questions, and then we'll see who else shows up. The first one is for you, Ms. Haycock-Lohman, and the Caring for Survivors Act increases the DIC and expands access to this benefit by reducing the number of years a veteran must be rated totally disabled for their spouse to qualify. Why is this important?
Currently, surviving spouses of those who died from military service are receiving lower benefits than other federal service. My husband works for the U.S. Marshal Service. My benefits would be higher under his service there than they would be if he were to die from his military service.
Okay. Ms. Bartlett, we have 5 education-related bills on this agenda today. One of those bills requires VA to update its payment system to allow schools overseas to accept student veterans. Why is this bill necessary, and why are students overseas having trouble accessing their VA benefits?
Thank you for the question, Chairman. Student veterans who choose to use their benefits overseas are having issues, and the institutions where they are at are having barriers to getting reimbursed through VA. There is a requirement, or sorry, there was not a requirement for an employee ID number or a U.S. bank account, but then they're finding that the process still does require that U.S. bank account. So if a student chooses to go overseas to use their benefits, the institutions are running into the barriers and challenges of being reimbursed and allowing those beneficial funds to come in to cover the cost of the tuition.
Okay. Ms. Robert, your members represent the veterans before the Court of Appeals for veterans claims. There's a bill in here to decrease the number of judges. Why is that important? And can you give me any sort of idea on what the timeline is now for, delayed justices?
Thank you, Senator Tester. Well, we do support that legislation and state in our written statement, and I think it's important to kind of look, as the PACT Act came into being, all different parts of VA are getting more resources. So we anticipate that as more claims are decided, and hopefully at some point the Board of Veterans Appeals is deciding more cases, that there'll be more cases that will potentially go up to the Court of Appeals for Veterans Claims. And we want to make sure that after all this has been put into the resources for the PACT Act, there's not a stall out up there, and that they need to have those judges.
Appreciate that. Mr. Lerman, you've already answered this question, but I'm going to ask it again in case you want to say something else in the minute 50 that I've got left. The GUARD Act is really important. For mere membership, why?
I think allowing people to pick and choose the veterans they represent, because they've said that. They have said that they're only taking cases they know they can win. So are they really trying to represent a veteran or just line more money for themselves? So are they really doing it justice in that way? They're also then deciding the fees that they get to charge. There are many veterans, I know just in the DC area, that were being told the only way you could get a claim done quickly is if you go to these claims agents. And that's not true. That's been debunked more than once. And I think one of the big things we'd like to point out is they have told us the people they represent are getting their claims decided in 5 to 6 months. And they made that sound like that was, oh my God, 5 to 6 months. Well, guess what? That's what everybody else is getting through a free representation and free help from somebody who's accredited. I think what they're doing is dangerous. They're setting expectations that are not realistic. Veterans are falling for that. Then they're coming to VSOs and those that don't charge for help when they need an appeal because they can't represent them at that point. So thank you, Senator.
I am sorry, I don't know. We're awful busy here. We have a lot of people that are in line to ask questions. Go ahead, Senator King.
This isn't really a question for the panel, but I think S-656 is a very important bill. It's the one that allows the waiver of the time lap for commercial driver's licenses. We desperately need commercial drivers, and we've got veterans who have that skill. They've learned it in the military, and we ought to be able to expedite that process. You're nodding. Can you say yes so it'll be in the record?
Yes,
yes,
Senator.
Senator King, you're absolutely right.
Yes, Senator King, you're absolutely right. And DAV fully supports this because we know that is removing another barrier for service-disabled veterans into employment.
Right, and it's an area of the economy where we need work, where we need commercial drivers.
Correct. I believe they said there was over 80,000 commercial drivers that are a shortage of that many commercial drivers in the country right now. So this is a way to get veterans into needed employment in a very quick way.
Well, let me broaden the question a little bit. One of the things that's always bothered me is that people learn tremendous skills in the military, and then they come out and they have to go through an entirely new licensing, apprenticeship, delay program. Talk to me about that. Is that something we should be addressing? I realize it's many times it's a state issue, but if somebody has electronic skills in the military and then they have to go through a lengthy process of relicensing that's expensive and time-consuming, I've never thought that made a lot of sense. Tammy, you've got your finger right on.
Finger on the buzzer. Thank you, Senator King. Along the lines you had mentioned electronics and looking at cybersecurity. That's why SVA supports the expansion and the improvement of the VA Vet Tech program. This is a program that VA had established for 5 years, and a GA report came out in the fall and found it was successful in placing veterans in that type of employment by them using their post 9/11 GI Bill monies to go towards certifications in those types of jobs. There is a bill at the House, and we just testified on it last month, so we're excited.
But it hasn't been introduced over here?
Not that I'm aware of, but we would.
Could you supply a copy to my office?
We would love to work with your office. Thank you.
Thank you. Other comments on the more general question of military skills being transferred into the private sector?
Yes, Senator. DAV, we have a resolution and we support finding a way to reduce or remove some of those certification requirements for a skill earned in the military. Now you got to go through that process in the civilian sector. And a few just real quick examples, HVAC, electricians, plumbers, people who've learned that and did those skills in the military can't go out and get a job unless they get recertified, go through an apprenticeship, and we're slowing down.
Take several years.
Right. When they should be ready for that job the minute they're out, because I've seen some of the setups people did when I was in the Marine Corps, and I would want those people doing the electricity in my house. So.
Thank you. You know about the lawyer that had a plumbing problem in his basement? The plumber came and repaired it, handed him the bill. The lawyer said, "I can't afford this." The plumber said, "I couldn't either when I was a lawyer." That's all, Mr. Chairman.
I don't know, Senator King, if you know anybody in the Armed Services Committee, but it may be an issue of credentialing that some of the fine members on the Armed Services Committee could take up to have the Defense Department.
I know a guy.
You do know a guy? Good.
Thank you.
I think, by the way, your points are spot on. I think we have traditionally undervalued the experience and the people have in the military and say, well, it just doesn't apply to the private sector, which is total BS, and you know that. And the folks at this panel know that too. That's exactly right. And truck drivers are in an interesting situation. I want to thank the VA for being here. I want to thank the VA for sticking around for the VSOs part of the panel. I want to thank the VSOs for being here today and the folks you advocate for. Both these panels, I think, thought were very, very good and give us some information. The record will be kept open for a week. Before I close, I just want to say something and use a little personal privilege. We just had a bill on the floor called the Elizabeth Dole Veterans Programs Improvement Act. It did not receive cloture. Let me tell you what this bill did. It established a grant program to expand the work of county veteran service officers, the folks on the ground who provide critical outreach and assistance to veterans seeking the benefits they've earned. We just talked about veterans hiring lawyers. These folks can give them information. This went down. Give them information so that they can make the right decision. A lot of these programs you guys deal with, and you know this, they kind of get kind of complicated once in a while, maybe unnecessarily so, but these veteran service officers play a really important role in expanding information. The other thing it did is it expanded access to home and community-based care programs for veterans. Now look, some veterans may not be able to stay in their home and might have to go to a veterans home, but those who can, we ought to be encouraging them to stay there. That want to, we ought to be encouraging them to stay there. That's what this would have done. Went down. It strengthened VA's long-term care programs, important for people who get hurt and they have an injury that disables them for their entire life and they're young people when they get hurt. Important. It made the Native American Direct Loan Program more accessible to Native Americans. This is a group that serves at a higher rate than any other minority in the country. It improves the VA's program, by the way, it went down. It improved the VA's program of comprehensive assistance for family caregivers by creating more appropriate processes for evaluating and assessing veterans who need mental health care, specialist care, or veterans with chronic or degenerative conditions. I don't have to tell the folks here it's why the VA is so important, is because the issues coming out of the Middle East have been mental health, PTSD, TBI. And when it comes to veterans that need special care, talk to the DAV about it. Talk about paralyzed veterans about it. These folks need help. And the last thing it would have, that went down, by the way. The last thing it would have done is require the VA to conduct a retroactive study on the effects of cannabis on veterans' health, followed by clinical trials. These studies would go for 2 years. They would be talking to veterans who have been using marijuana, already using marijuana, and see if it works to deal with things like PTSD or chronic pain. Now, what's the other option? Just give them the stuff and say, well, we don't know, but you know, go ahead and use it? No, I think it'd be great to have some science backing this up. Otherwise, you know what they're using? They're using opioids. Very addictive. That went down. That was the issue that took the whole thing down. And look, we've got bills out there to bank marijuana. We got states, including my state of Montana, that legalized it across the board. The truth is marijuana's here. Whether you like it or you don't like it, it is here. So let's get some science to back it up so the veterans know what's going on to see if it actually does help with chronic pain, which, by the way, is a huge issue, or post-traumatic stress disorder, which is a huge issue. The Senate usually does some good work, did some good work getting Josh Jacobs for the veterans benefits confirmed earlier today. This is not a stellar day for the United States Senate. And I would hope that the veteran service organizations let the 42 people, it went down 57 to 42, so we didn't get cloture, let those 42 people who voted against cloture for this, make them justify that vote. Because this, in my neck of the woods, would be what comes out of the back end of a bull. With that, we'll keep the record open for a week, and this hearing is adjourned. Thank you all.